Welcome to this guide on how to get a settlement agreement in 8 simple steps. Let's get to it. Step 1. You've been treated badly and you've decided you're just not going to put up with it anymore. That's important, your decision. Sometimes we think, do you know what, it's not that bad, we could just get on with it. But when it's been repeated several times, over a week, over a month, over a year, maybe don't let it get that far. But it's been repeated a few times, you've decided, I can't do this anymore. So that's your step 1. But what should you do? Step 2. Raise this with your employer in an informal way. Perhaps HR, management, just have a frank conversation about what's happened and see if you can explore ways to mediate the situation without it escalating. Do tell your employer you want to hear back from them with a resolution, an idea on how to fix things, perhaps in 5 days, depending on how long this has happened for. Now, bear time in mind. In employment tribunal, time limitations are really tight in that you have only 3 months minus 1 day from the date of the incident until the day that you have to lodge your claim, or at the very least start ACAS early conciliation. But that's something for another time. So, time limitations, very important. So if this incident that you're complaining about happened about 2 months ago, be very, very careful, because at that point you have less than 1 month left before you have to action things. So don't allow your employer to delay you. Now, 7 days has gone past since you've raised this with your employer. There's been no response. There's been no action taken, even where maybe they've promised they'll take action, but nothing's really happened. What should you do next? This is where you now need to think about, do I want to stay working for the company or would I like to leave? Which brings us to step 3. You've had no decision from your employer, or at the very least, they've said they'll do something, but they just haven't. At stage 3, you now have 2 options. As I said, you need to decide, do you want to stay with your employer or would you like to leave? Have you had enough? Now, if you want to stay with your employer, we suggest that you escalate it with a formal grievance. Now, your employer will be forced to follow perhaps company policies on grievances. And if they don't have that, there is at the very least that cushion that ACAS gives, as there is an ACAS guide on how to handle grievances. This may allow your employer to bring about a way to mediate the situation so that they find a solution for you to be able to return to work and continue your employment in some form of peace for you. Of course, leaving your employment should not be done lightly, should not be thought of lightly. However, on that occasion where you think, right, this is too much for me now, and I want to leave, step 3, option 2 is seek legal advice. Seek legal advice and figure out what kind of legal claims might you have in employment law. And this is where you contact Monaco solicitors. Now remember, if you do wish to contact employment law solicitors and you want to leave your employer, please do so without delay. That time limitation is still there. The clock is always ticking, the time does not pause. You do not want a good employment tribunal claim to be time barred simply because you left it too long or delayed it too long. We know these situations can get extremely stressful and sometimes we get overwhelmed and we don't necessarily want to deal with it immediately. But that's what we're there for as your solicitors. We will ask you for some details about your case, but predominantly we'll push on with it in the negotiation stage. So let's talk about the next stage at that point then. Stage 4. You contact Monaco solicitors by making an inquiry. You submit a brief breakdown of your situation. Let us know what has happened at work to bring you to this particular stage. You will be contacted by Monaco solicitors within the hour of making this inquiry, and you will be given a few options. You may be offered a free 10-minute consultation. This will happen in the case that, having reviewed your brief summary, our solicitors deem that there is enough there for them to see a potential for a negotiation. And in that 10-minute consultation, you will discuss what type of services we can offer you and how we can help you going forward. The other option is that you may be offered a paid consultation. Now, paid consultations are recommended in a situation where we may deem that your claim is a little bit more complex and requires us to do a little bit more of that case review. So we need to review perhaps some documents. You'll be given a time slot with the solicitor, and we will ask you for the necessary documentations for us to review to tell you what type of claims you might have if those claims are available. And then you will be told as to whether or not we can go forward with the negotiation services. Now, bear in mind, Monaco solicitors, we specialize in settlement agreements. We specialize in obtaining settlements, exit packages, and the like. Therefore, it's only natural that we offer this particular service on a no-win, no-fee basis. So the whole point of these reviews that we've just mentioned is in order to see if you can get a no-win, no-fee service for us to negotiate a settlement agreement or exit package for you. So there goes your step 5. You will be informed as to whether or not we can offer you that no-win, no-fee negotiation. Now, no-win, no-fee means no upfront payment is required, and the only fees due will be if and when we obtain a settlement for you. So this is a percentage that is applied to the final settlement that we are able to obtain for you. We will discuss these fees with you before you even sign an agreement of terms with us. We will discuss perhaps what type of settlement you are looking for before we enter into this business agreement with you as well. So we will offer you our terms of business for you to review and see if you're willing to accept it. The other service that you may be offered are hourly paid rates. Sometimes a case, unfortunately, does not allow for the no-win, no-fee service because perhaps what you're looking for is not necessarily a settlement agreement, or you don't want to leave your job, you just want someone to provide you with some documentation. Bear in mind at this stage that Monaco Solicitors also has plenty of self-help tools that we can offer. Number 1 is our website, which contains an immense amount of free legal advice and guidance. And the other is the Monaco Solicitors AI tool. This tool can help you if you wish to represent yourself through settlement negotiations or even represent yourself at an employment tribunal. We will give you guidance on what these tools are and how to use them. These tools are either free of charge or the AI tool is at a much lower percentage. So ask a Monaco Solicitors representative and they will speak to you about that too. So let's get down to it. Step 6, you have accepted our business terms and you are ready to now discuss what kind of settlement you want to obtain and just contact your employer. We will ask you to provide us with a timeline of events and supporting documents in order for us to start preparing our without prejudice communication with your employer. This may be via email, letter, or phone call. We will contact your employer and ask them if they're willing to engage in a negotiation with us, having presented them the type of legal claims that you might have. Now, step 7 is the communication between us and your employer. There may be a slight negotiation there. We make one offer, they might make a counter offer, which is best case scenario, by the way, because at this stage we just want engagement. And eventually we'll see if we can meet at a middle ground where you're happy with the offer they've made and they're happy to make that settlement offer, and we can move on to their next steps. Step 8. You've reached an agreement in principle with your employer. Now, that doesn't mean that the whole agreement is settled already. It just means we're in good grounds. They've made an offer, you've accepted it. We will ask them to provide us with a draft settlement agreement. We will then provide you with advice on the terms and effects of the settlement agreement. If any slight amendments need to be made, we will make those suggestions. And once you and your employer have come to an agreement of what these terms of the settlement agreement might be, you can both sign the document, and at that stage, congratulations, you have reached a settlement agreement. Your claim will probably have been waived depending on what the terms are on the settlement agreement. But up until that stage where you have signed your settlement agreement, please note, if you have not lodged your claim yet, 3 months minus 1 day deadline is very strict. keep an eye on that timeline. Even if you think, it's okay, my employer is going to sign this document today, but your deadline is tomorrow, bear in mind, there's a chance that they're not going to sign that document for any possible reason. You should probably lodge your claim at that stage. In any case, I hope this has been very helpful. If you would like to see a simple bullet pointed list of the 8 steps I have introduced today, please go to our website and look for 8 simple steps to reaching a settlement agreement. It's all there.